And another shocking rape case where justice has not been done. Old enough to be raped but too young to testify. That's the cruel irony facing a mother fighting for justice for her 4-year-old daughter who was raped. After 9 years of going back and forth in several courts, the accused has been acquitted. The 4-year-old, who was badly brutalized and even hospitalized for 2 years, pointed the man out who assaulted her but was too intimidated to speak, so her rapist walked free.
For this mother, it's been a long struggle to get justice for her daughter. In 2003, her 4-year-old daughter was raped, then brutally attacked allegedly by a neighbour. Though arrested on the mother's suspicion, the accused was acquitted twice, both by the Sessions as well as the High Court. All because the child, just 4 years old that time, could not answer questions during a cross-examination in an open court. She had, however, identified the accused as the rapist in court. But the Delhi High Court, upholding the previous verdict, cited, "There is a possibility of tutoring a child witness," saying suspicion, however strong, cannot take place of proof.
छोटी सी लड़की क्या बता पाएगी? पूछा तो उन्होंने मेरे से कह रहे थे कि क्या नाम आपकी बच्ची के कपड़े हैं, तो मैंने कहा हाँ जी.
The investigators found blood-stained clothes in the room of the accused and in a park at the behest of the accused, but that could not be connected to the case and no DNA match was found. But the larger question being raised by this case is, can a minor rape victim as young as 4 be cross-examined in open court? According to the previous law, the discretion lay with the judge. If a child was old enough to understand the questions, she can be examined in open court. But new laws which have come to existence recently after objections raised by child rights activists recommend a more child-friendly approach. The Prevention of Child Sexual Offences Act of 2012 says, a child's statement should be recorded at the residence of a child or at a place of her choice, and it has to be recorded as spoken by the child. Also, there have been several rulings by the High Court and the Supreme Court which says that if the child has to be examined, then it should be done within the judge's chamber.
Ultimately, judge has to see, the court has to see whether that's, because whatever is being done is done on the statement of a prosecutrix.
They will not be able to recall, and also they will not be able to defend themselves.
Even 10 years on, the girl, now a teenager, is suffering. She doesn't remember much as to how she got the scars, but has to go to the doctor every week to get help.
In the case of a minor being raped, the onus of proving innocence lies with the accused. And there are several new laws like the POCSO Act, which actually recommends a more child-friendly approach while dealing with these cases. But for several mothers and daughters like the one that we met today, is the new law a little too late? In New Delhi, Tanima Biswas for NDTV.